Screen share. Good evening, sir.
Good evening.
Good evening, everyone. I am Pranjal Wankade from Corona Remedies. As you know that Corona is among the top 5 gynecologists company in India, and being a responsible organization, we at Corona Remedies always support and participate in the different scientific programs such as the CME and webinars. Corona is serving a gynae fraternity as a dedicated academic partners, and every time we bring a new topic with the latest updates and expert opinion. This time we are initiating a new series of webinars on the medical legal aspects. We are here with the second program of the series, that is consent, how much is too much. So medical legal problems with the subject expert, Dr. Gitendra Sharma. We are pleased to have Dr. Gitendra Sharma as an expert faculty for this webinar. He is the practicing gynecologist in Ahmedabad for 30 years, MD in Ops and Gynae, Medical Legal Counsel, done his LLB with 15 gold medals, taught in Gujarat University Law. He is the author of books like Law in Ops and Gynae Practice, second book of Consents in Ops and Gynae, and third book, Law a Doctor Must Know. Dr. Gitendra Sharma has given more than 1600 lectures and 10 oration overall India. Dr. Gitendra Sharma is a vice president of Foxy in 2022 to 23. He was a chairperson in Ethics Medical Legal Committee of Foxy in 2017 to 2019. Dr. Gitendra Sharma is a president of AOGS in 2016 and 17 and hosted AICOG in 2017 January. So I'm sure this webinar will be helpful for all doctors in their day-to-day practice. So welcome Dr. Gitendra Sharma, sir. I hand over session to you, sir.
Thank you, Pranjal, for giving a kind introduction. And at the outset, I would like to thank Corona Remedies people for giving me this opportunity to interact with all of you through this webinar. So, shall I share my slides now?
Yes, sir, you can share.
Slides are visible? And
yes, sir, it's visible. Yes.
Oh. So today we are going to deal with consent. Consent, how much is too much? That is the topic of today's webinar. So, dear friends, we must know consent, and it is a need of the hour because many judgments by different commissions and courts have come only depending upon the consent. See, we always tell our colleague while discussing medical legal topics that why these medical legal topics are to be discussed. So the answer is because the litigation against doctors are increasing day by day. And most of the litigations, I can say the maximum litigations are against gynecologists. And being gynecologist, I am more worried for myself and for my fraternity members. To avoid medical legal litigation, we should take care of multiple C's. What are those C's? So our conduct with the patient and the relative should be proper. If your conduct is proper, you can definitely avoid problem. You should avoid criticizing your colleague. So if one doctor criticizes the another, that attracts the medical legal problem for other doctor. So we should avoid criticizing our colleague. We should not be careless in our practice. We must maintain confidentiality of the patient. We should do proper counseling and proper communication to the patient. We can avoid complication. And if you will take proper consent, if you take care of all these C's, then you will be saved from all these C's. That is litigation in consumer law for compensation, under civil law, under criminal law. litigation in complaint filed in state medical council or national medical council, complaint filed against you at CMO office under Clinical Establishment Act, or complaint filed in Chief Minister's or Prime Minister's office. There are multiple commission, Human Rights Commission, Women Rights Commission, and multiple fora where complaints can be filed. So, dear friends, if you take care of all these C's, then you will be saved from these C's. To understand consent, see, we all must know what is consent. Before 2008, everybody was taking consent in their own way. And everybody was taking blanket consent, that what they take in writing from the patient. I am giving authority to the doctor to do operation on my body. I give all authority to doctor to remove whatever is required while operation. Whatever organ is required to be removed, I give full authority to the doctor. I give full authority to doctor to give any kind of anesthesia. And I give authority to doctor that if need arises, he can shift me to another hospital for further care. So that kind of blanket consents we all used to take previously. But in 2008, a judgment came. That was a 3-judge bench judgment by Supreme Court. And after that, clarity has come that what is the meaning of consent. So to understand consent, we must know these 3 things. One, what is agreement, what is contract, then we will be able to understand what is consent. If we define agreement, agreement means where 2 or more parties agree to the same thing. So 2 people when agree to do something, same thing, then it is known as agreement. When agreement is made enforceable under law. So that means if an agreement is in writing, signed by 2 parties or more than 2 parties among which the contract is been made. So if it is made enforceable, so if it is put on paper, it is signed in front of witnesses, and if it is signed by both the parties, and then it will become a contract. Contract can be void contract, can be valid contract, can be voidable contract. So dear friends, the consent is a valid contract. So we should understand that your consent should be a valid consent and valid contract. Now, for a contract to become a valid contract, it must take care all 4 of these things. The first thing, it is mentioned under Indian Contract Act that for a contract to become a valid contract, the consent of parties who are contracting or who are signing the contract should be a free consent. We will look into that, what is the meaning of free consent. Then parties who are signing the contract should be competent. Again, we will look into that, what is the meaning of competent party. And the object should be lawful. So the object or the purpose of taking consent should be lawful. So you cannot take consent for illegal purpose. And it should not be declared to be void, means void, it should consent or contract should be for a legal purpose. We should take care of that. Now, what is the meaning of free consent? Free consent means consent which is not caused by coercion, means undue pressure. So if you will apply undue pressure on a person to give consent, then that consent is not a free consent. Consent should not be obtained by undue influence, by fraud, by misrepresentation, and by mistake of fact or law. So if these 5 things are to be taken care, then your consent will be considered as free consent. Otherwise, if the consent is obtained by applying coercion or undue influence or fraud or by misrepresentation or under mistake of fact and law, then that consent will not be considered as free consent. Now, what is the meaning of competent party? So any party who is signing the contract should be competent. So any person who is above the age of 18 years with sane mind, who can understand whatever is explained to him or her, then it is said that it is a competent party. So both parties must be major, that means above 18 years, because contract with minor is void ab initio, and that is mentioned in one of the cases, that is landmark case of Dharmadas versus Mori Bibi, in which it was told that you cannot contract with minor because contract with minor is void ab initio. In case where the person is not major, means minor, then you should take consent of a legal guardian. Then competent party means the party who who is not insane or mentally retarded. So anybody who is above 18 years but not with sound mind or insane or mentally retarded, then also these cannot be considered as competent party to sign. And in that case also the legal guardian should sign. The person who is under the effect of intoxicating substance or anesthesia, under the effect of anesthesia, are also not considered as competent parties. So any person who is above the age of 18 years with sane mind, not under the effect of intoxicating substance or anesthetic substance, is called competent party. So any party who is signing should be competent to sign. Now, third thing, that the object of the contract should be lawful. So lawful consideration and object should be there for taking a consent. For example, if you are taking consent for illegal purpose or unlawful purpose, that will become void ab initio, and that is not a valid contract. For example, if a patient gives you 1 lakh rupees and try to contract with you or give a consent that please kill me by giving a particular injection, and if you kill that person, that is known as euthanasia, mercy killing. So contract for euthanasia is illegal ab initio, because it is not allowed in India. Euthanasia is not allowed in India. Again, for if we take second example, then suppose two people contract to divide the profit of prostitution business, and one person denies to give profit to the another partner. So in that case, if that another partner goes to the court, what court will say? Court will say that this contract is void ab initio and we cannot implement this contract under law, because prostitution business in India itself is illegal and you cannot have any contract for illegal purpose. So your object should be legal. Purpose of taking consent should be legal. So ultimately what we have understood, that what is consent? So consent is a where two or more persons are said to be in consent when they agree upon the same thing in same sense. That means parties ad idem. So consent is a valid contract where four things are necessary. There are different kinds of consent. You can say that there is one implied consent. So implied consent means it is implied by the behavior of the patient that he has or she has come for a particular treatment. So suppose a patient who has entered into a chamber of a dentist and sits down on the dental chair and opens the mouth, that is implied. So no consent for examination of your tooth is required for a dentist, because it is an implied consent by the behavior of the patient that he or she is ready to be examined by the dentist. Consent can be expressed. So again, expressed consent should be expressed either orally or in writing. It is very difficult to prove in the court of law the orally expressed consent, and that's why we should avoid taking oral consent and rather stress upon taking written consent. Now, we all know that there are a few things which we should keep in our mind. One is a valid consent, that is informed consent. So informed consent means we should inform a few things to the patient before taking consent, and that is known as informed consent. What things are to be explained, we will come, we'll know in next slides. Negative consents are more important sometimes than positive consent. So suppose patient is refusing to take some kind of treatment which is explained to them, then in that case, it is always advisable to take refusal consent from the patient, so that in future you can be saved by showing that consent that patient was not ready to undergo this particular treatment. There are different kinds of consents nowadays developed, and we are taking those consents. For example, consent for admission, consent for a particular treatment, consent for particular surgery, blood transfusion consent. There are different consents, high risk consent, physiotherapy consent, or multiple different kind of consents. Anesthesia can be considered a separate thing, separate procedure. So anesthesia consent should always be taken separately. So basically, we must take before giving the treatment or before doing any kind of surgery, we must take a written consent from the patient. We all know that before 2008, we were not knowing that what is the kind of consent we should take. But in the decision of Samira Kohli versus Dr. Prabha Manchanda's case, that was a judgment by 3-judge bench of Supreme Court. The Justice Ravindran delivered the judgment, and judgment was given by the bench of Justice Agrawal, Justice Nawalkar, and Justice Ravindran. After this judgment, clarity came in the medical field that what kind of consent should be taken, when it should be taken, how it should be taken. So everything was explained in this judgment very clearly by the Supreme Court 3-judge bench. Let us see what was the fact of this case, because this was a landmark case. So we should know that what are the facts in this case. So on 9th May 1995, one patient named Samira Kohli, she was unmarried, of 44 years age, visited the clinic of Dr. Prabha Manchanda. Now, she visited Dr. Prabha Manchanda with the complaint of prolonged menstrual bleeding for continuously 9 days. Now, the doctor examined the patient and advised to undergo ultrasound test on the same day. After ultrasonography, she found that there is multiple fibroid and bilateral chocolate cyst is there. So to confirm the diagnosis, to reach to the affirmative diagnosis, after examining the reports, the doctor had a discussion with the patient, and doctor advised her to come on the next day, that is 10th May 1995, for a diagnostic laparoscopic test under general anesthesia for confirming the diagnosis. Now, patient came on next day, nil by mouth, and the appellant went to the doctor clinic with her mother. On admission, the appellant signature was taken. So the patient's signature were taken. And where the signatures were taken? Signatures were taken on admission consent, as well as on discharge card in advance, then consent form for hospital admission and medical treatment, and consent form for surgery. So these many consents were signed by the patient. Admission card showed that admission was for the diagnostic and operative laparoscopy on 10/5/1995. Consent was taken by the assistant of gynecologist Dr. Prabha Manchanda, Dr. Lata Rangan, who was assistant to doctor. And doctor described to the patient that we will do diagnostic laparoscopy, and we may require operative laparoscopy in some case, and in rarely we may require laparotomy for your treatment. Now, appellant, after taking proper consent by the assistant doctor, was taken on table, put under GA, and subjected for laparoscopic examination. Now, when doctor started laparoscopic examination on laparoscopy, she found that this is a case of endometriosis grade 4, because everything was adherent. So ovaries were adherent to in the pouch of Douglas with the uterus, intestines were also adherent to the chocolate cyst, bladder was also adherent, and there were multiple adhesions all over the abdomen. So on table, it was decided by Dr. Prabha Manchanda that this patient requires treatment by doing total abdominal hysterectomy plus bilateral salpingoophorectomy. Now, when the appellant was still unconscious because she was under GA, Dr. Lata Rangan, who was assisting the respondent, means doctor, came out of the operation theater and took the signature of appellant's mother, who was waiting outside operation theater. Now, she explained everything to the mother, and she took consent for hysterectomy plus bilateral salpingo-oophorectomy from the mother. Thereafter, the doctor performed an abdominal hysterectomy and bilateral salpingo-oophorectomy. Now, appellant was to be discharged after 5 days on 15th. So, appellant left the hospital 5 days later without settling the bill. Now, on the day of discharge, one of the friend of that patient, who was commander in military, Commander Zutsi, came to the hospital and he started abusing the staff member and doctors of the hospital, telling that why you have removed uterus of my patient without her own consent. So you have done something wrong. You are negligent in treatment. You explained only to go for diagnostic hysteroscopy, and you said that only around 9,000 expenditure will be there. And now you have done abdominal hysterectomy, total hysterectomy with bilateral salpingo-oophorectomy, and your bill is 39,000 rupees, 325 rupees. So in that case, without settling the bill, they took discharge from the hospital and they went home. Now on 23rd May, doctor lodged a complaint with the police, alleging that the appellant's friend, who was commander in military, Commander Zutsi, had abused and threatened her, and they took discharge against medical advice, and he got the patient discharged without settling the bill. So that was the complaint of doctor. Now the respondent also issued a legal notice dated 5th June demanding rupees 39,325 for professional services. So doctor waited for 15 more days that patient will come and settle the bill, but patient has never come back. So doctor also issued a legal notice to settle the bill. Aggrieved by all these things, now patient filed complaint of negligence for unauthorized removal of reproductive organ on 31st May 1995. They filed case or at National Commission demanding 25 lakhs rupees compensation on 19th January 1996. Why this complaint was filed in National Commission directly? Because in 1996, the pecuniary jurisdiction was such that if anybody demands compensation more than 20 lakhs rupees, then they used to file directly case at National Commission level. So this case was directly filed at National Commission. The allegation of the patient were that doctor is negligent in doing treatment. Radical surgery by which her uterus, ovaries, and fallopian tubes were removed without patient's consent. And when she was under general anesthesia for a laparoscopic test, the removal should be considered as unlawful, unauthorized, and unwarranted. So what they said that all of these organs were removed without my consent. Now she is suffering due to premature menopause, necessitating prolonged medical treatment by hormone replacement therapy. And we all know that hormone replacement therapy have multiple side effects. They also argued that now she has lost her reproductive organs. So she has lost the opportunity to become mother. So that friend of that girl of 44 years who was unmarried now was telling that I was going to marry her next year, and now our matrimonial prospects are diminished or over. Now she is not able to become mother, so her matrimonial prospects are now near to nil. Irreversible permanent damage you have caused for pain, for emotional stress and trauma, for decline in health, and for increasing vulnerability to health hazard. They demanded compensation of 25 lakhs rupees. Now, in that case, National Commission held that the appellant voluntarily visited the clinic. Nobody asked her to go to the clinic of Dr. Prabha Manchanda. She voluntarily visited the clinic for treatment and consented for diagnostic and operative procedure. And the hysterectomy and other surgical procedures were done with adequate care and caution. So surgical removal of uterus, ovaries, etc. was necessitated as the appellant was found to be suffering from endometriosis grade 4. And if they have not been removed, there was likelihood of the lesion extending to the intestine and bladder and damaging them. And whatever doctor has done is according to the medical standard, and National Commission dismissed the complaint. Now, aggrieved by this decision, the patient filed an appeal in Supreme Court in 2004. This judgment of National Commission came in 2004. So, patient filed an appeal at Supreme Court what patient said, that I am not telling that doctor is negligent in doing the treatment, but my argument is that my reproductive organs are being removed without my consent, and that's why the compensation should be granted. Now, very first time, whatever is the decision by the Supreme Court, we will have a look on it. But the important thing in this decision, that Supreme Court very first time categorically defined that what is the consent in regard to medical context. So they put 7 questions and they answered 7 questions in such a way that it should clear in the minds of every doctor that what do you mean by consent, when it should be taken, how it should be taken, who should take the consent. So everything was answered in these questions. So first question Supreme Court raised in this case, that whether informed consent of a patient is necessary for surgical procedure involving removal of reproductive organ or any other surgical procedure or medical treatment. The answer to this was that a doctor has to seek consent, seek and secure the consent of the patient before commencing a treatment. And the term treatment includes surgery also. So that means whatever treatment where there are possibilities of multiple side effects, or if you are doing any kind of surgery on the patient, then you must take consent of the patient of her own. So you have to take patient's consent. Relatives are signing as a witness, but patient's own consent is must when patient is sane about the age of 18 years. So what they said, that every human being of adult years, so every human being above the 18 years and a sound mind has a right to determine what should be done with his body. And a surgeon who performs the operation without consent commits an assault for which he is liable in damages. So under tort, you can be held liable under for damages under tort. And in IPC also, any intentional touching of a person is unlawful and amounts to tort of battery unless it is justified by consent or other lawful authority. And for doing assault, there is provision of up to 6 months imprisonment under IPC. So you have to be careful that you cannot operate on a patient or you cannot touch even patient without her consent. Otherwise, it will be considered as unlawful. Now, the second question raised by Supreme Court, that what is the nature of consent? So what is the, how it should be taken? What is the nature of consent? So the answer came that the consent should be real and valid. Now, what does it mean? The court said that valid means it should, consent is a valid contract in between doctor and patient. And for becoming a contract to be a valid contract, we have already seen that the consent of parties who are signing should be a free consent. Second, the parties who are signing the consent should be competent to sign. Third, the object of that consent should be legal, should be lawful. And Supreme Court very first time added the fourth thing in relevance to medical context, that if you are taking consent in medical field, then you have to pass on, it is your duty that you have to pass on adequate information to the patient before taking consent. So, dear friends, these 4 things are to be taken care of. What is real and valid consent? Let us understand what is the difference between real consent and informed consent. we are all puzzled. Even Supreme National Commission in recent judgment of RG Stone Hospital is puzzled, and everywhere they have used the term informed consent in place of real consent, real or valid consent. See, real and valid consent is a thing which is followed in UK. See, we have been ruled by UK for many years, so we are following most of the things which UK people are now following. So real and valid consent means the consent is a valid contract in between doctor and patient. And for consent to be for contract to be a valid contract, we have seen that four things are to be followed. It should be a free consent, the party should be competent, the lawful object should be there. The last thing which Supreme Court has added, that you have to pass on adequate information. Now, what is informed consent? So informed consent is something which is followed in America. So in America, what they say, that it is a duty of doctor to provide literature, to provide all information in regard to the treatment of the patient to the patient before undertaking patient for the treatment. And there is no signature of doctor and patient simultaneously. But doctor provides the literature to the patient. They provide links to the patient so that patient can learn what is going to happen on her body. And then doctor takes only patient's consent. So their consent paper is only signed by patient, that I have gone through all the literature and link which have been provided by doctor to me. And now I am satisfied and I am ready. I know everything about this treatment and now I am ready to undergo the treatment. So in that way, only patient signs the complaint. While in valid consent, it is a contract in between doctor and patient. And that's why doctor signs, patient signs, and two witnesses signs. So that is real and valid consent. So dear friend, we must understand that informed consent means to pass on adequate information is only one part out of four of valid consent. So valid consent is a broad thing which we are following in India. We are not following only informed consent in India. Now, immediately the question came in the minds of the three learned judges, that we have mentioned that adequate information should be passed on to the patient. But what is the meaning of that adequate information? So they categorically defined that adequate information means 6 things are to be informed to the patient. First, nature and procedure of treatment should be explained. What is the purpose of treatment should be explained. Then benefits and effects of the treatment should be explained. Alternatives, if available, should also be explained. An outline of substantial risks are to be explained, and adverse consequences of refusing treatment should also be explained. So if you explain these 6 things to the patient in writing, that become a real and valid consent. Now, Supreme Court has mentioned that there is no need to explain remote or theoretical risks involved, which may frighten or confuse the patient and result in refusal of treatment which is necessary for the patient. So, for example, if an anesthetist will tell the patient that 1 out of 1,000 may not come out of anesthesia and may die on table, so no patient will become ready for a surgery which is even required for their treatment under the fear of death. So we should not frighten the patient or confuse the patient by providing such information. But on the other aspect, Supreme Court has also mentioned that similarly no need to explain remote or theoretical risk of refusal of treatment, which may persuade the patient to undergo a fanciful or unnecessary surgery, which is not required at all. So a balance should be achieved in between these two things. So information should be of that extent which is accepted as normal and proper by a body of medical men skilled and experienced in that particular field. And that's why there is need to develop the common consent for routine operation by national organizations of different fraternity members. Supreme Court, in defining these things or clarifying more on this aspect, has given 2 examples that there are 2 exceptions where you may not pass on adequate information to the patient before giving the treatment. First, where there is a genuine emergency and patient is unconscious or not in position to give consent, then you may proceed with the treatment if it is to save the life of the patient. And second, where the information would be harmful to the patient. So sometimes if we believe that if we will divulge the information to the patient and it will cause psychological or physical or emotional harm to the patient, then we may not divulge that information to the patient. To clarify all these things, in this Samira Kohli judgment, 3-judge bench has categorically put 2 judgments from the Canadian High Court. And one case was the Murray versus McMurtry. In that case, during cesarean section, doctor found big fibroid in patient's uterus. Being of view that such tumor would be danger in future pregnancy, he performed sterilization operation so that if patient will not become pregnant in future, then there will not be any problem. Now, court upheld the claim for damages in this case. And what court said, that court held that the sterilization could not be justified under the principle of necessity because there was no immediate threat or danger to the patient's health or life in this patient. And what they categorically mentioned, that arguments like it is beneficial for the patient or it would save the time, it would save pain and suffering of patient in future, these kind of argument doesn't stand in the court of law. So you cannot exceed your consent unless something which is done by you to save the life of the patient, which we should keep in our mind. So another case which was again by the Canadian Supreme Court mentioned in this judgment by the Supreme Court said that in one case, that was a case of Marshall versus Curry. In that case, doctor discovered a grossly diseased testicle while performing a hernia operation. Doctor considered it to be a gangrenous, posing a threat to patient's health and life, removed it without consent as a part of hernia operation. So doctor took consent only for hernia, but he removed the testis because the testis was gangrenous. Now patient filed a complaint and the claim of the patient was dismissed by the court, saying that the court was of the view that the doctor can act without the consent of the patient where it is necessary to save the life or preserve the health of the patient. So dear friends, whenever if you have any patient of cesarean section on table and patient undergoes severe PPH, now if you do not have consent with you for obstetric hysterectomy, even then to save the life of the patient, you can proceed for hysterectomy even without consent. So these are the things which we should keep in our mind. So consent given for specific treatment, you cannot do other procedure unless it is life-saving. So this is the principle of necessity. So if there is principle of necessity, then you can proceed further without consent also. But if there is no principle of necessity is not justified, then you cannot do or proceed more than your consent. In Code of Medical Ethics, Medical Council of India has mentioned that whenever you do any operation which leads to sterilization of a female or a male, then the consent of spouse must be taken. But simultaneously, in different manuals which have come out by Government of India, it mentions that consent of only patient is enough. So there is discrepancy in between two things, and we can definitely help you if such cases are filed against you under this pretext. Now, the fourth question raised by the Supreme Court, that can the consent for diagnostic surgery be construed as a consent for performing additional or further surgical procedure, either as a conservative or as a radical treatment, without specific consent for such additional or further surgery? The answer is no. For example, if we have taken consent for diagnostic laparoscopy, can we proceed for cauterization of ovary? Answer is no. So consent for diagnostic procedure you cannot do an additional therapeutic procedure if you have not taken proper consent. The fifth question was, can there be a common consent for diagnostic and operative procedure where they are contemplated? So answer is yes. You can take two consents in one, amalgamate the two consents. There is no problem in that. So if you have taken proper consent for diagnostic procedure and SOS operative procedure, you can definitely do that procedure. But the procedure which you want to do should be apprehended beforehand. Now, the sixth question was, can there be a common consent for a particular surgical procedure and an additional or further procedure that may become necessary during the course of surgery? Again, the answer is yes. But the adequate information regarding both the surgeries should be clearly explained to the patient beforehand. The last and least, but not the least, the seventh question put by the Supreme Court said that can consent be taken by assistant doctor? The answer was yes. See, assistant doctor who is competent to explain or to give all these adequate information to the relative or to the patient, then he or she is competent. But what is normally routinely done in hospital, that the consents are being signed without explaining anything by the nurses, which is not valid. So definitely assisting doctor can take the consent. Now in this case, the decision of Supreme Court came that can the doctor be, the question put forward was, can the doctor be held negligent in taking decision of total abdominal hysterectomy with bilateral hysterectomy on table? So answer was no. The reason, because Supreme Court took expert witness advice, so opinion of expert witness, Dr. Sudha Salhan, and Dr. Sudha Salhan gave her opinion that doctor is not negligent in doing the treatment. Even I would have been there, I would have taken the same decision because patient was suffering from endometriosis grade 4. So the Supreme Court has said that doctor is not negligent in doing the treatment. But second question came, is the doctor still liable? So the answer given by Supreme Court is yes, because doctor has done operation without proper consent, because they have taken consent of diagnostic laparoscopy, operative laparoscopy, SOS laparotomy, and the consent of laparotomy cannot be considered as consent to remove the reproductive organ. So consent of laparotomy cannot be considered as consent for bilateral total abdominal hysterectomy with bilateral salpingo-oophorectomy. So dear friends, for not taking proper consent, 25,000 rupees compensation was awarded, 39,325 rupees bill was waived, and 5,000 rupees cost was awarded to the patient. And the words of wisdom used by the Supreme Court, that the correctness or appropriateness of the treatment procedure does not make the treatment legal in the absence of consent for the treatment. So even if you are not negligent in doing treatment, but if you have not taken consent for the treatment, then it will amount to negligence on the part of doctor. This case has been referred to and cited several times subsequently in many cases. In one of the cases of Mrs. Jeba Amit versus Hajela Hospital and others in Bhopal, again, doctor did ovarian drilling and salpingectomy without consent. And on the grounds of this Samira Kohli's case, the compensation was granted. In case of Mrs. Chandok versus Sir Gangaram Hospital, now in this particular case, patient was suffering from dysfunctional uterine bleeding. She was having history of 2 previous cesarean section. Patient was, the consent was taken for total abdominal trans-abdominal hysterectomy. Now, when patient was taken on table, when doctor examined the patient, it was found that this was the case of 3rd degree descent. So on table, doctor decided to go for vaginal hysterectomy. Now consent taken was for abdominal hysterectomy and doctor resorted to vaginal hysterectomy. Now when he applied clamp vaginally, there was severe bleeding, which could not be controlled vaginally. And ultimately, he had to resort to abdominal route. When he resorted to abdominal route, he found that this is the case of ectopic kidney, and patient needed nephrectomy in this case. So the judgment says, in this case, judgment came that you cannot deviate from the route for which you have taken the consent. If you have taken consent for abdominal hysterectomy, you cannot start with vaginal hysterectomy. So for changing the route of the surgery, 5 lakhs rupees compensation was granted in this case. In another case of C. Jaipal Reddy versus Dr. Yashoda Group of Hospital and Dr. Padmini Velluri and others, this was the judgment given by National Commission, and this was the ex parte judgment. Doctor never appeared, or hospital never appeared to defend themselves. What happened in this case? Again, the case was of endometriosis. Patient was taking conservative treatment for 9 months, but as patient did not improve, then doctor decided to go for hysterectomy. Consent was taken properly and the hysterectomy was done. Now, in this case, doctor signed the consent paper, patient signed the consent paper, but the blanks which were there in the consent paper remained unfilled. So, court presumed that the doctor who do not have time to fill the blanks which are there in the consent paper, how we can presume that doctor would have explained all the pros and cons, or regarding the procedure, all the have given adequate information to the patient, and it was presumed